Thank you, Mr. Chief Justice, and may it please the Court. Historically, judgments entered in the absence of personal jurisdiction have been described as a nullity, utterly void upon entry, lacking any legal effect, and odious to due process. Accordingly, they have routinely been vacated without reference to any specific period of time or deadline, and courts have noted that it is per se an abuse of discretion for a court not to vacate a void judgment. In this action, the lower courts did not determine whether the judgment was void. Rather, they held that Coney Island took too long to bring its motion for vacatur in violation of Rule of Civil Procedure 60C1, which requires such motions to be made within a reasonable time. This Court has never had occasion previously to consider whether Rule 60C1 applies to judgments void ab initio or the definition of reasonable time. We respectfully submit that the lower courts erred because, as a matter of logic, Rule 60C1 cannot apply to judgments void ab initio. And the reason for that is that if the judgment is void immediately upon entry and remains so for all time, there cannot be a time after which the judgment cannot be vacated, because a judgment that is void ab initio cannot suddenly spring to life, become active and enforceable through the passage of time alone. To harmonize the doctrine of void ab initio and reasonable time, the Court may find, as it has in the past, that a defendant believing that a court lacks jurisdiction may elect to ignore the proceeding, suffer the default judgment, and then collaterally attack that judgment when the judgment creditor attempts to enforce it. Enforcement, however, must be adversarial in nature, or actually invading a personal interest, for example, a contempt proceeding or seizure of a bank account, such that ignoring it would be tantamount to a waiver of a known right or acquiescence in the judgment. If enforcement were defined as any action at all trying to collect on a judgment, such as mailing post-judgment discovery, then it amounts to that post-judgment discovery essentially acting as a supplemental, unauthorized process, because the mailing itself would commence the time period, the expiration of which would cause a subsequent application for vacatur to be denied as untimely. I welcome the Court's questions.
So you're not arguing that your motion, your 60B motion, was filed within a reasonable amount of time?
We believe, Your Honor, that there is no reasonable amount of time within which a judgment that is void ab initio can be vacated.
And how is void ab initio different from the grounds listed in 60B, the judgment is void, that as a basis for the motion?
We believe, Your Honor, that a 60B4 applies to both void judgments and voidable judgments. And so when a judgment is voidable, there is no reasonable time limitation, because at that point the court that had entered it had jurisdiction, and for some other reason the judgment should be held void, as opposed to a void judgment which has no legal effect right from the beginning.
So how do you respond to respondents' argument that you're conflating the merits with the timeliness of the motion?
Well, we believe, Your Honor, that if a judgment is void ab initio, there is no timeliness aspect that would that should cause a court to not vacate that judgment.